I now give the floor to the distinguished representative of Sri Lanka. You have the floor.
Madam Chair, thank you for giving me the floor. May I also convey my thanks and good wishes to our co-facilitators. Madam Chair, during the last century, millions of human beings perished as a result of genocide, crimes against humanity, war crimes, and other serious crimes. As envisaged in the preamble to the draft, women, men, and children have been the victims of crimes that deeply shock the conscience of humanity. It is a living reality that we experience in contemporary times, a reality that continues to threaten the peace, security, and well-being of the world. We must, I say, take cognizance of the fact of international law on this matter being embodied in the Charter of the United Nations. We must also take cognizance, as some academics, and as we have heard it this morning, that it is a peremptory norm that must be given primacy of place, while of course other academics think that it does not have the status of the jus cogens. We have to concede that perpetrators deserving of prosecution have only rarely been held accountable. It is observed that the preamble presents a broad reflection of contemporary international criminal law, similar to the preamble to the Rome Statute, which is mindful that all peoples are united by a common bond. We must, however, appreciate that this approach has many shortcomings, particularly the idea that of one-size-fits-all distinction between international and domestic offenses in the circumstances gets very complicated. This is one area I believe that needs to be carefully considered. Madam Chair, we must stand firm on the footing that to stop this cycle of violence and to promote justice, impunity for the commission of serious crimes must yield to accountability. We know that that is easier said than done, of course. But how can this be done is the question. And what will be the respective roles of national courts and international tribunals is another aspect that we need to give our mind to seriously. Madam Chair, international law describes an international crime as an act that international law deems universally criminal. The international law requirement is what distinguishes an international crime from a domestic crime, although some acts that qualify as domestic crimes are universally criminal. Their universality, of course, is not derived from international law, but from the fact that every state in the world has independently decided to criminalize them. Now, we must appreciate the national courts administer systems of criminal law designed to provide justice for victims and due process for accused persons. A nation's courts exercises criminal jurisdiction over crimes committed in its territory and proceeds against those crimes committed abroad by its nationals or against its nationals or against its national interests. When these and other connections are absent, national courts may nevertheless exercise jurisdiction under international law over crimes of such exceptional gravity that they affect the fundamental interests of the international community as a whole. It must be appreciated, Madam Chair, that universal jurisdiction is a jurisdiction based solely on the nature of the crime. National courts can exercise universal jurisdiction to prosecute and punish and thereby deter heinous acts recognized as serious crimes under international law. When national courts exercise universal jurisdiction appropriately, in accordance with internationally recognized standards of due process, they act to vindicate not merely their own interests and values, but the basic interests and values common to the international community. Universal jurisdiction holds out the promise of greater justice, but the jurisprudence of universal jurisdiction, unfortunately, is disparate, disjointed, and poorly understood. So long as that is so, this weapon against impunity is potentially beset with incoherence, confusion, and at times even injustice. Mr. Chairman, Madam Chair, international crimes sometimes are also called, as we know, core crimes. There are crimes such as war crimes, crimes against humanity, genocide, and aggression. We now see the crime of torture being added to the list. We have also seen the controversial matters from terrorism to crimes against the environment and corruption. It must, however, be appreciated that criminalization of these offenses is not merely about which of these specific acts warrant the status of international crimes. We must realize that it also involves what treating them as international crimes would entail. What are, I ask, the defining features? What is that warrants a special treatment of these offenses? What is the international component we need to have? Is it some sort of transnational crime? So we need to therefore distinguish these features and appreciate the distinction. International criminal tribunals also have a vital role to play in combating impunity as a complement to national courts. In the wake of mass atrocities and of oppressive rule, national judicial systems have often been unable, of course, or unwilling to prosecute serious crimes under international law. So international criminal tribunals have been established. Treaties entered into in the aftermath of World War II have strengthened the international institutions and have given greater clarity. A signal achievement of this is the United Nations Conference in 1998, when the Rome Statute of the International Criminal Court was adopted. Now, when this permanent court becomes effective, the international community will acquire, I say, an unprecedented opportunity to hold accountable some of those accused of serious crimes under international law. The jurisdiction of the International Criminal Court will, however, be available only if justice cannot be done at the national level, and that must be appreciated. The primary burden of prosecuting the alleged perpetrators of these crimes will continue to reside with national legal systems. So there we are. Enhancing the proper exercise of universal jurisdiction by national courts will help to close the gap in law enforcement that has favored perpetrators of serious crimes under international law. Nevertheless, the aim of sound principles cannot be simply to facilitate the speediest exercise of criminal jurisdiction, always and everywhere and irrespective of the circumstances. We must be guarded against improper exercise of criminal jurisdiction, including universal jurisdiction, as it can be used merely to harass political opponents or for aims extraneous to criminal justice, as in the case of politics and the misuse of law. So what is needed are principles to guide, as well as to give greater coherence and legitimacy to the exercise of universal jurisdiction. I thank you, Madam Chair.
I thank the distinguished representative of Sri Lanka for his statement.